Hey, how's it going? We're waiting for the audience to respond for you.
They're not going to respond. So, welcome to consultation. My name's Josh Floyd.
My name is James Palin.
And I'm Julie Prentice.
All right, and so we are all attorneys here at the Jimenez Law Firm. Since nobody said that, because y'all are following my lead and I didn't say it.
Yeah.
And we get together every Friday at noon to discuss, just some legal issues. People send in questions. We have a little roundtable discussion, sometimes discussions / arguments, whatever it may be. But it kind of gives you insight as to what it's like, day-to-day life of an attorney. I mean, we hardly ever agree on anything because we're all attorneys and that's what we do.
The one who argues.
Do what?
Floyd's normally the one who argues.
Yeah, because I'm usually right? And so I've got to make sure you guys understand that. But I'm going to say it now, and then I'll say it again in the middle if James or Julie reminds me, because I usually fail at that. And then I will for sure say it at the end. Don't take anything we say here as legal advice. You'll hear a lot that it depends on this or depends on that, or if this, if that. And so if you do have a legal issue, go find somebody that is experienced in family law, that practices in the county where your case is going to be, and get advice from them, because it really does turn on the smallest of facts, or even which judge you're in front of can make the biggest difference in the world. So don't take it as legal advice, just enjoy the discussion. Hopefully to give you some insights, some things to ask, and just some entertainment.
Yeah, it's pretty entertaining. I'd say so.
I think so. It's more entertaining, I would say, when Christina's not on, right? I think that's fair to say.
I think you're actually very fun.
Yeah, I'm not going to say that like publicly, but we know, right? Okay. James wants to keep his job, so he's going to remain silent.
Absolutely.
All right. Follow us on social media. James, you were trying to catch me slipping.
I was wondering if you were going to get it. I was ready to pounce.
Yeah. So follow us on social media. We, I believe we're on Facebook, right? Don't we have Facebook?
Mm-hmm.
Yeah, I think we're on Facebook. We're on all of the platforms, TikTok and LinkedIn and Twitter and Snapchat. I think I saw a couple of those come across over the weekend.
Oh, wow.
Yeah, right. Okay.
Didn't they? Yeah, you were in one, James.
I was on Snapchat. Okay. All right. I love Snapchat and Instagram, which were also.
Shoot, maybe it's Instagram, not Snapchat. I don't know. I'm too old.
I think it's Instagram.
Yeah.
Okay. Yeah. I don't really know the difference in those two.
MySpace too. I'm just kidding.
I don't know if we're on MySpace.
No. Okay.
No. Well, we really should be, so that we can say we're on all the social media platforms.
Right.
I don't think that one's a thing anymore.
I don't know. Okay. Want to get this show started?
All right, let's do it.
So James, you wanna ask the first question, por favor?
All right, let's see. Am I entitled to receive monies from a trust fund that my ex-husband hid from me while we were married? Okay. My ex-husband and I were married for almost 14 years, and he owes me a substantial amount of child support, almost $65,000. So it sounds like he owes you a lot of money from child support, but I thought we'd get a little bit more information about the trust fund. But even still, the question remains, am I entitled to receive monies from a trust fund that my ex-husband hid from me while we were married? What do y'all think?
So
I think the $65,000 is in addition to.
Okay. Got it. All right. That makes sense. All right. So I think the question here is, during a divorce, if one spouse hides something like a trust fund from the other spouse, and that's not divided, presumably, because it was hidden, right? Is there any way you can go back and get it? Yes. There is, right? It's a post-dissolution division is what it's called. And basically the statute, the law says that, you know, all marital property shall be divided in the divorce, right? And so if there's a piece of property that is not divided, either because it's hidden, it's forgotten about, or whatever, you just file a post-dissolution division or file for a post-dissolution division, and then go in and establish that it was community property that you're entitled to and that it wasn't divided, and it'll be divided. I mean, I guess. What?
Can we talk about the trust fund?
Yeah, what are you gonna talk about?
Well, trust funds are usually gifted, right?
Oh, okay. You wanted to make assumptions. Okay, yeah, go ahead.
Well, I mean, we can kind of read into the question just to, I mean, so we can give her the best answer we can, right? So with those gifts, if it were indeed gifted to the husband as his separate property, then you could commence this, but it could wind up being a waste of money. So, I mean, yeah, there's, like what you're saying, Mr. Floyd, the post-dissolution. However, if it was a gift, then she might just be spinning her wheels.
Yeah, I mean, that's true. That's certainly something that your attorney should look into. But even then, so any property owned by the parties is marital property, right? And he has the burden to prove that it's separate property, right? Presumption would be community. So he's got to prove that it's separate property. But like you said, if in fact it's clearly separate property, you're wasting your time bringing the case. But even with separate property, right, it needs to be confirmed as one party's separate property in the divorce so that you're disposing of all the marital funds. Kind of like in this case, let's say that it is separate property, right? That someone left him a trust and he's got a trust fund, which I don't know why she left him if he's got a lot of money in trust, but whatever, right?
There's more things to marriage than money, but you just kidding.
Oh, okay, yeah. So yeah, no, I don't even know where I was going with that now. So if it is, yeah.
Because you're thinking of all the reasons someone would leave somebody.
I guess, although technically it should have been confirmed as his separate property, if in fact that's what it is, in the final decree, you don't want to spend the money to go back and have that done when you don't get anything from it, right?
So does the child support play into this?
No. Well, it's a whole separate issue, right?
Right.
As to whether you're entitled to any portion of that trust fund as a division of the marital estate has nothing to do with the child support. Now, can you get some of that money because of the $65,000 he owes you in child support? Julie.
So you can get a judgment for back child support and go from there. And then how it gets paid, maybe it's out of that fund, maybe it's out of something else. But as far as the calculation of it, his income does go into the amount of child support he would have. And once that judgment's in place, he can get the money, maybe it's from the trust fund, maybe it's from something else.
Yeah, so it depends on how the trust is set up, right? God, this is taking me back to law school, James. You probably best to answer this question, but I know there's like different types of trusts, like some that you have to wait on and some you don't or whatever. Is there a condition precedent? Is that the right word?
Right. Yeah.
That was
Yeah.
impressive, Floyd.
I actually think that's property law, not wills and trust, but
I mean, wills and trusts deal with a lot of property. So that the two almost go hand in hand. But the reason I even brought it up was because
you wanted to be difficult and make this question incredibly complicated.
Well, no, yes and no, but also because most trusts, I mean, they're for the individual, right? I mean, I know you're a rich man. when you set up the trust for your
Are
children,
we allowed to lie on Facebook?
when you set up the trust for your children, are you planning on, including their potential spouses? Probably not.
So fortunately, that's not a question I'm ever going to have to deal with.
Okay. All right.
I am spending
Don't fool
all
y'all
of my
Facebook.
money. They can earn theirs.
Yeah.
Well, so I guess the question would be, so like you were saying, you get a judgment, right? And then in order to collect on that judgment, you get a lien against it, right? Actually, Christina, I was just dealing with this issue, and there's another document that you have to file, but I don't remember what it is. But anyways, but the question would be whether he is presently entitled to the funds in the trust to where you could place the lien on it, right? And so if it's something where he's not entitled to the trust, I remember this example, unless he graduates from college with a master's degree, that's in a case of wills and trust. And if he never graduates with a master's degree, he never gets that money, right? And so you couldn't put a lien on it if he's not entitled to it. Make sense? No?
And
James, just out of law school.
right. I think the better play, instead of going for this trust, is to go for the child support, because you have a child support order. And if the 10-year statute of limitations hasn't run, then you have a good shot.
Well, that's what we were talking about, was putting a lien on the trust for child support.
Oh,
Since we can't go after the trust, or based on your assumptions, right? It would do us no good to go after the trust. Then
but why go after the trust even so, and run the option that, hey, maybe the trust never gets put in his name, when you can go after his money now, assuming that he has some sort of job or income.
Well, what if he's got $100,000 sitting in trust, but he doesn't have any money in his accounts, right? Then you could go collect a whole $65,000 via lien on the trust.
I think it's worth the legwork to figure out if it's community or separate property and to go through it. It's definitely worth the legwork.
Yeah, because you don't want to do the lien on it and then find out that it's community property and you're actually entitled to 50% of that anyway. And you got to lien against you. That would be complicated.
Yep.
Yeah. Okay, this was a good question.
It was. That was a fun one. That was a fun one. All right, I'll ask the next one. If I marry my wife, so
are you married or?
It's a little tricky. Okay. And she's on child support and I take her last name, would I have to pay child support? I should have read this question before we started.
Wait a second.
We got married. So they are married. So it's not an if I marry, it's I did marry. So we got married, but I'm scared to take her last name because she is on child support. I want to know, will it affect me? Very non-traditional.
Okay, so she's on child support. Yeah, so she's on child support, and I mean, your wages won't be garnished, but let's say she's working for you, and potentially you have to garnish her wages from the check that you pay her. I mean, that could affect you in some manner. Dealing with the attorney general, but you don't have an obligation to pay child support. It's going to be hers. If something terrible would happen and at some point you all got divorced, that would still be her obligation.
Answer is no. You can take her last name if you want to. You're already married.
Right.
So taking the last name has zero impact.
Yeah. So I mean, that's just, it's not going to be your obligation, no matter what your name is.
But, what if she's a stay-at-home mom and, he makes bank like you, James, 250,000 a year or something, right? And
Except
so they're rat holing all this money in a joint account. And they don't have quite as much as you, James. They got about 150 in there stashed away.
what do we
And she gets behind on support. Can they attach to that account?
do? To our joint account?
Yeah.
Yeah, I mean, it's her account too, so.
So that would affect them, right? I mean, think about it right now, right? If your wife had a child support obligation attached to your account where you have all that money, that would affect you. You'd be pissed.
Indeed. So the attorney general can get at your assets, and that includes your bank account. And so if you share, I mean, so would the prudent advice, yeah, I mean, the logical conclusion for prudent advice would be to maintain separate accounts. Is that what you suggest, Mr. Floyd?
And the prenup while we're at it,
I
just
suggest you pay her child support. Then we don't have to worry about it.
Yeah.
Because it's not just accounts that they buy a house together. Can they put a lien on them? Right? It's anything that she's entitled to if she's not going to pay her support. So just make sure she pays her support.
So I guess the bigger question, I want to know, will it affect me? Absolutely. You're marrying someone with a child and child support obligations.
Yeah, so it's going to come out of your joint income.
But the way I initially read the question was, can he, well, yeah.
but it's not related to the last name. You did that when you married her.
Right.
Yes. So I think his initial question was, can he be put on the hook for it? Right. And the answer is no, but they could attach to anything that she owns, right? Which may be partially yours as well.
Unless you came in with everything. I already had my own house, had my own car. You just adding to this what I've already built.
Yeah.
It's a Disney child in my head right now with all that.
Yeah. Another good question.
Anything else on that?
I think that covers it.
Who's up?
I'll read one. How do I get my ex-wife?
Wait, Gretchen is too busy today to work, but she can get on Facebook and like commenting.
She's on vacation.
She's commenting on.
Come on.
But she can't work today.
Oh, this is what happens when you support the troops. You get called out on Facebook. And I ain't forgot last week either, Floyd.
He tell you about that, Julie?
No, he didn't.
No.
I'll tell you. So we were on Facebook Live, CJ and I. I already put it out there last week. And in the middle of it, he calls me. And so I tell him.
It was in the middle. It was the near end. Okay.
The point is we were still on Facebook Live. And so I showed to Christina that he was calling. I was like, clearly James isn't watching our Facebook Live. It was quite humorous.
Speaking of that, since we're in the middle, it's not legal advice.
Yes, there we go.
That's the only time we'll ever have a good transition to it.
Maybe that's why he was calling me to remind me that.
Right.
Exactly. Had you had picked up the phone, sorry.
I was busy talking to our audience.
Sorry. Water under the bridge.
Well, clearly not, because you brought it up.
I think there's a little salt in there.
You salty. It's okay. Go ahead. Who's up? What are we doing here?
All right. How do I get my ex-wife to drop my last name? I've been divorced for the last 4 years. My ex-wife refuses to change her last name. I want to get married to my girlfriend. I want my ex to drop my last name and move on.
There's a lot in a name.
Good luck with that.
Yeah, so unfortunately, there isn't a legal instrument to force your wife, unless you all had a prenup or unless you all had it in the divorce agreement, which it doesn't sound like you did. Yeah, unfortunately, she's going to have to do that on her own free will. But that doesn't mean there's nothing you can do. Ours is a profession of persuasion, right? And so there's lots of different ways you can go about persuading somebody.
Are we allowed to talk about it on Facebook?
Well, yeah, I mean, I'm not talking about, come on, man.
Okay.
we went to, they talked about in law school, right? You got your pathos, your logos, your ethos, right?
No.
Nobody knows what I'm talking about. Y'all know them. Where's Sarabi?
He's freestyling this.
No, it's a thing. So it's a thing. It's not the answer to this question at all.
It is. It is. All right. I'm saying, look, you can persuade someone. There's 3 ways: pathos, logos, ethos. Y'all Google it. Tell me if I'm lying. Logos is the logic portion. You appeal to their reason. Pathos, you appeal to their emotions, right? Ethos, you appeal to their sense of credibility. So, or not their sense of credibility, you establish yourself as a person with credibility, so they take you more seriously. It's the reason why celebrities sell things on, I'm not about to get into this with y'all. You can persuade your ex-wife through these multitude of fashions to drop your last name. If you want to appeal to her emotions, let her know that you're trying to live a new life with this lovely woman. If you want to appeal to her logic, tell her, hey, look, my last name isn't doing you any good. You can probably get further with it. If you want to appeal to her sense of credibility, you want to get somebody who has established reputation in this field, like Mr. Floyd, to go talk to her and convince her.
All right, I'm doing it now. James, what if they've got kids, man? What if that's her kid's last name?
Yep.
If they've got kids and their kids got last names,
No, they didn't give them last names, but hypothetically speaking, let's say that they did in this case.
hypothetically, if the kids share the last name of the mother.
If they got last names at all. And they happen to be the same as the dads and the moms.
Well, look, let's talk about it. Logos, right? The reason behind it. I'm gonna skip that one. Let's go to the emotion. Sometimes kids don't know what's best for them, okay? Right, that's why you don't let your kid eat lollipops for breakfast. So the kid may think, hey, look, I want the same last name as mom. But at the end of the day,
But it would be the mom wanting the same last name as the kids.
sometimes mothers don't know what they want.
You can say
Just
that
kidding.
again.
Just kidding.
No, your wife's listening, isn't she?
Your
They
wife, your mama, like you got a sister.
They always know what they want. I'm not going to be painted into this corner. Look, as I said before, there are many ways you can persuade. Unfortunately, there's not a legal instrument. Final answer.
Well, and if it's that big of a deal, change your name.
That's his name.
Well, it's hers too.
But she took that on. That wasn't always her name.
No. So a name is like separate property. He gave her that name. It's now her name, right? If she wants to change it, she can. If she doesn't have to. And so if he doesn't like it that much, he can change his last name.
True story.
There's more than one way to skin a cat. Not that I condone skinning cats, but
You heard it here first.
PETA.
All right, let's get you a question, Julie.
oh, speaking of your wife, you should look at the Facebook comments. Yep, that was all him.
I'm sure it was supportive, and
So now he's scared and he's
because we are a unit, and the love that this family carries is unlike anything I've ever seen.
All right, who's reading the next question?
Not me. Now I'm trying to find James' wife's comments.
All right.
It says, interesting point, Mr. Palin.
And I wasn't speaking from personal experience. Let me just say that right now. I was speaking in the general overall that sometimes, I mean, we see a lot of family cases, lots of family cases. And in our profession, sometimes moms, fathers, brothers, sisters, they change their mind.
Yeah, I mean, I've been doing this 10 years. I've never ran across it. So I don't know. This is actually my first time to ever hear about it is from you.
Man, hey,
So, must be personal. I'm not sure, but
don't shoot the messenger. That's all.
all right, who's up?
All right, let me give one for Julie. What are things that I should know about in preparation for divorce? I need to know my rights. What should I be paying my spouse for alimony, for my children, assets, and etc.? Where should I file? Do I have to use a lawyer if we both agree on financial and other matters? What do you think?
Holy shit. This just opened up every statute in the code.
Yes, it did.
Go, Julie.
Get a lawyer.
Have a sip of water.
Yeah, no. So while this is not legal advice, yeah, get a lawyer. There is a lot in the code. It is very, very specific. And it is fact specific to your case. So what should you know? The basics in Texas, you file for divorce. Once you file,
Julie, did James just type this question out after his wife's comment?
I think he did actually.
Okay, I didn't know if it was.
Yeah.
We're just
I know
all
he is.
types of conjecture.
Or actually, no, I think his wife actually wrote it in. I'm not so sure. I think that's what happened.
Look, see, now my family's getting brought into this. I'm gonna have to have a conversation with Jimenez. Okay.
All right. Sorry, Julie. Go ahead.
No worries. So you file for a petition in Texas, right? And once you do that, the other party gets served. They answer or they don't answer. If they don't answer, it goes into a default proceeding. If they do answer, then it takes 60 days. Well, either way, it takes 60 days to get a divorce in Texas. That's a statutory minimum for it. What do you need to know? It's very fact specific. You're going to have pay stubs, bank records, all sorts of documents and things that you're going to need. Do you need a lawyer if you both agree? I always say it's best to have a lawyer because there is all sorts of nuances in getting your property taken care of. So.
Touche. Yeah. Yeah, I mean, I don't know if this is a question we can answer like this. You need to know your rights. Like what rights? Like your rights to property? Like, yeah, I don't know how to answer this question.
He said children too.
Yeah, I would need to know much more. Alimony?
Wrong state, buddy. But
and I like how you answer, where should I file? Texas? Like there's not like 86 counties in Texas.
I'm telling you, it's more fact specific. Do you live in Dallas? Do you live in Odessa?
Well,
I'm not going to mention the other parts because they're not as fun.
But part of this is our fault. We have to take some responsibility because the podcast is called The Consult, right? And these are all questions that someone would want to know in a consult.
This is true. And we would have the opportunity to say, okay, well, tell me what's going on so that I can answer these questions for you. Here, we know nothing. And so it's very difficult to give any kind of advice on it. So let's talk in generalities, right? So nothing crazy going on. Let's presume this is a woman that comes in. What do you tell her about her rights to her children, James?
Rights to your children. I mean, you can make decisions. Right now, it sounds like there is not an order in place. So do what you do. Take them to school, bring them home, lay them home to sleep, make sure they're fed. And if the father of the children is still in the home, all the better. If not, you're going to want to co-parent as best you can. And then get an attorney to get some formal orders in place. But those are your rights. I mean, he has the rights to see the children. He has the rights to, if he's not in the home, make decisions for the children.
Yeah, so I guess in summation, your rights don't change when you're preparing for a divorce, right? I mean, they're exactly the same way they were the day before you guys got pissed off at each other. You both have the same rights. You both have the right to possession of the children and duty to support them and all of that. And until an order goes in effect, that's the way it is. Talk to us about alimony, Julie.
It's not a thing in Texas. There is such a thing as spousal support. You have to be, I mean, there's a number of statutory factors that go into it. I believe it's 10 years, married 10 years, and trying to figure out how to say this appropriately, but if you don't have the capacity to earn yourself, then you can get it on a temporary basis. It's very rare that it happens, especially in this county. And also very rare that it's something that is long term. So normally it's getting you to a point where you can support yourself. So
Okay.
and it's based on minimum necessities and what you need. It's not necessarily like, oh, can I go buy a Ferrari or whatever? It's your basic living needs.
And again, whether you pay that depends on the facts, right? I mean, are we dealing with a stay-at-home husband with a wife that makes bank like James does, or are we dealing with, you know, two people that are equally employed? And I mean, if you're a stay-at-home husband and your wife's making bank, or if your husband is a stay-at-home husband and you're making bank, you probably should make sure you can pay his bills, right? If you kicked him out, right, and left him on the streets and whatever, right? You need to make sure you're taken care of, because you still have that duty to support your spouse. That duty continues, even though you hate each other. You still have to support one another. Not like James has really supported his spouse on this show, but you just really need to support him.
Look, but you know, it's the beautiful thing about what we got here in the Pearland home, you know, come hella high water, winds, rocky, hail, sleet, snow, hot weather, cold weather, any type of weather. Like, we know what we got is unbreakable. So baby, they're gonna keep trying us. They're gonna try to break us apart. They don't want to see us win. It's too late. We already got the victory. It's too late. So let them hate, let them throw stones. They don't hurt us.
All right, who's up?
Oh well.
Let James answer one. Julie, you want to read it?
Sure. In which state do I file for divorce? My husband and I were married in Texas, where we lived together for several years. We also lived together in Washington, D.C. My husband still lives in D.C., and I now live in Texas. In which state do I file for divorce? This was a good question for you since you've lived in both.
That's pretty good. Yeah, that's pretty good. Well, you still live in Texas, right? My husband and I were married in Texas, lived together for 9 years. We also live in, my husband still lives in DC. I live in Texas. Yeah, well, you live in Texas, so I'd file in Texas if I were you. Now, it's gonna be a lot easier to get to court, right? I'm unfamiliar with the divorce laws in the District of Columbia, but it's all gonna boil down to jurisdiction. And the state of Texas, now that you've lived here, how long have you lived here? You've been in the county for the requisite amount of time. And have you lived in the state for the requisite amount of time? Several years. It doesn't say how long you've lived here. Well, if you've lived in Texas for the requisite amount of time, which Floyd, I'm sure, is jumping on to tell me.
No, you already know. I don't have to tell you. You already know.
Okay. Yeah, I believe it's 6 months. And then you're free to file here in Texas. And yeah, they'd have jurisdiction over them. And you all can settle your matters under the rules of this great state.
Yeah, so yeah, I guess it's not clear where they live, right? So in Texas, if she has lived here for 6 months, then and she filed first, then she would have dominant jurisdiction, right? You would have to get an attorney in California to fight the case in California. He's consented to jurisdiction by filing his response. So I think it stays in Texas as long as you've lived here for 6 months. But you do have to get an attorney in California. Whether jurisdiction will be proper in California or not, I don't know. Julie, you did a lot of studying on the California statutes. What say you?
I did not. Once again, I'm going to point out that this is not legal advice. You can be a lawyer in your own jurisdiction.
Yeah, not just your own county, but your own. Let's start with state, right? Find somebody in the state where you need them, and then the county. Yeah, California and Texas couldn't be more polar opposites. So I have no idea what their statutes say.
It is a lovely state to go visit.
So if you were in, I don't know how long he's lived there. Anyways, Texas would be dominant jurisdiction, so she would win them. All right, and you want me to read one?
I'll read one for you because I think this is a common question that gets asked a lot. Does it matter which party serves first in a child custody case?
No. Next question.
There you go.
Yeah, no, it is a question. I race to the courthouse. And I say no. It does not matter with respect to who's going to be primary visitation child support. It may matter with respect to where the case is going to be heard and where the child is going to live, right? So if it's just a child custody case and no divorce, yeah, no. It's just a child custody case, and it's wherever the child is. So there would only be one proper venue. So shit, I just confused the whole question. I mixed it up with the last question. Not doesn't matter where they file, but who serves first. Yeah, it doesn't matter at all. A lot of people think that they get some type of leg up by filing first, and it really doesn't matter. Sometimes there's advantages, like you get to be a petitioner, you get to put on your case first, judge hears your evidence first, right? But sometimes there's an advantage to being a respondent. You let them put on their case first, and then you can just pick it apart. Whereas if you're a petitioner, then respondent puts on their case after you, and it's not as easy. So yeah, as far as who wins and all that stuff, doesn't matter who serves first. I was trying to think if there would be any. I can't think of any advantages to it. So they got a TRO.
Yeah, extraordinary relief, right?
Yeah, if you did extraordinary relief, but even then it wouldn't matter who filed first, right? I mean, if I'm petitioner and you file for extraordinary relief as respondent, what does that matter?
It shouldn't.
Yeah, judge could still grant you extraordinary relief.
I think there's some jurisdictions where it might matter a little bit, but legally it should not.
Now, what if mom and dad, they're obviously split up, which is why there's a custody case or potentially a custody case. And okay, you know how there's that provision in the TRO that says can't change the child's place of abode, all that stuff, right? And so if at the time of filing the child is residing with mom, and so she files while the child is with her, would that be helpful? Like, you're still disturbing the peace by not continuing to do what you're doing. I don't see any advantage. There's no advantage to filing first. I can't think of one.
Legally, there shouldn't be.
Yeah, there's not. Yeah. Okay. All right. I'll read. All right. So what can I do about owed child support if I didn't know I was supposed to be paying? Last time we went to court was 6 years ago and we never went back. We both agreed to handle things between us and not through the court. But I received a letter in the mail for $55,000 of owed child support. I wonder if this is the guy from the other question where it was 65.
Think so? Maybe the trust was only 10,000.
Yeah. $55,000 owed child support, but I thought we had an agreement. Anybody got a professional or unprofessional opinion on this? James. Oh, sorry. I thought your wife did. I thought, oh, shit, got him.
So I got
him.
I'd like to redact my previous statements as upon further review. Mothers always know what they're talking about.
There you go.
Okay. Do you need me to read the question again for you, James?
Yes, please.
What can I do about owed child support if I didn't know I was supposed to be paying? The last time we went to court was 6 years ago and we never went back. We both agreed to handle things between us and not through the court, but I received a letter in the mail, $55,000 of owed child support, but I thought we had an agreement.
Well, did you prove this agreement up in front of the judge? That's going to be the key question. If not, then I hope you got receipts for the payment that you did give your wife, because unfortunately that agreement is not enforceable. You still owe child support. And I'm curious as to the contents of this agreement, because it says you went to court. And if you went to court, I'm assuming that there was an order for you to pay child support in the manner in which you were to pay child support. So if you made a back deal, yeah. Unfortunately, you still owe child support. I would look to mediate with the Attorney General and show proof of the payments that you made. They may be somewhat lenient, but if there's an order to pay child support, you have to pay your child support. And if you have an agreement to modify, you need to get that proven up in front of the judge so that it's enforceable and everybody knows what you're doing.
Yeah, so I actually ran into this issue. I assume what happened is they went to court, there was an order for support, and then maybe they decided not to pursue that or something, right? So, well, I'll just tell you. So in my case, it was dad was ordered to pay support, and they agreed to suspend withholding, and dad was going to make the car payment for mom in lieu of paying child support. Right? And until a few years later, mom gets mad and says, you haven't paid me any support. And he says, oh, but I made your car payment. And she says, yeah, that was a gift. Thank you. But you still owe me child support. So there's usually a clause in there that says you don't get credit for informal payments, right? So like the purpose of that clause is if you owe support, say you owe $500 a month and you take your child out and buy them $100 worth of clothes, you can't say, here's $400 and here's a receipt where I spent $100, right? Mm-hmm. And to prevent any type of confusion and things like that. So generally you do not get credit for what we call informal payments. Sometimes you can get it, sometimes they'll give it to you, but the presumption is no way, you're not gonna get credit for it. So if you had an agreement, like James said, I hope it was like reduced to an order. Yeah, otherwise, yeah, you owe some child support. Anything else on that?
Well, quick follow-up. So earlier, much earlier, I was asked whether owed child support, right? Mom says, hey, I'm going to put you on child support. And he had an option whether to go to the hearing or to mediate. with the Attorney General. And so wanted to see if you guys had any thoughts on that. If
What
there's
was
a
the
preference
question?
for pro se's when there is when there's a child support order on the way, and they have the option to either mediate with the Attorney General or go to the child support hearing, which one they should go with and why.
I mean, I don't think it hurts to talk to them. Right? Let me caveat that. Don't do anything without an attorney, right? Because there's a lot more that goes into calculating support than what the Attorney Generals will do. They tend to have a lot of issues with like self-employed, right? So if you have some type of claim where someone's claiming I'm self-employed, I only make X dollars a year, when really they're bringing in a lot of money, or if you have like an intentional underemployment or something like that, the Attorney Generals are just too busy to explore all of those different options for you and help you try to prove income. So I think it depends, but never go without an attorney, right? And spending a few $1,000s on an attorney could save you, you know, go out here $55,000 later, maybe, I don't know. So we are good investments, right? I mean, some people invest in stock markets. Smart ones invest in attorneys, right? Good quality attorneys that can advise them and save them money in the long run.
I think that should be on a t-shirt.
It should be. It should be.
Stocks, Bitcoin, or attorneys. It's pretty
Do
good.
what?
I said stocks, Bitcoin, or attorneys.
Yeah.
Pretty good.
So I mean, but generally, so with one of those conferences you're talking about, James, you can go to them, you don't have to agree to it, right? And so where people get tripped up on that though is they'll go to them and then not agree to the order, and then the Attorney General will file for confirmation of a non-agreed child support order, right? Where just one party signed and the Attorney General signed, but the other party didn't, right? And then they missed their deadline to challenge that, which I believe is 30 days, maybe 20, I don't remember. But I think you have 30 days to file an objection to it. And if you don't, judge signs it, and it is what it is. You missed your deadline. So if you go to one of those conferences and you don't have an agreement, you should call someone like Mr. Palin to really help you take care of that. Unless he's dealing with family problems and stuff, then you can call Julie. But yeah, you need to get an attorney ASAP if you go one of those things, don't have an agreement, because they very likely could be filing a non-agreed order and you'll be stuck paying what you didn't want to pay. See? Cool. Who's up next?
I think it's your turn.
Okay, I'll read this one. I'm divorced, and in the settlement, my ex got the house. Now she is selling it, but my name is still on it. Do I have any rights? I tried once before to get my name off the mortgage, but the mortgage company sold to another company and it never happened. Of course, the house is worth 3 times more than what it was years ago, with my name still on the house. Do I have any rights to the house equity or any rights at all? What do you think?
It depends.
Okay.
But I would say probably not, right? Because she was awarded the house. So the chance of you having any claim to it would be slim to none. This is something we run into a lot, where the final decrees are not drafted correctly. There should have been language in there that said she had X number of days to get the house out of your name. And if she didn't, then she had to sell it, so that you're not going on for years with this mortgage in your name. Doesn't matter that the house tripled in equity. She was awarded 100% of the house. She gets the house. Yeah, I mean, it's pretty straightforward, right? You are, the only thing that you have is a right to pay that debt. Other than that, you don't have a right to any of the equity because your name is still on the mortgage. And let's talk about that, like debts during divorce, right? So both of their names are on it. And if the house, along with the mortgage payment, was awarded to wife, but she doesn't make the payment, can he go to the mortgage company and say, look, here's a decree, I'm not responsible? She is. No, she can't. You can't do that. So that's the funny thing about debts. And I think we've talked about it on here before. I guess James wasn't listening because he was calling me. But so the order can't change who the creditor holds liable, right? And so if you have joint credit cards or anything like that, a debt that's in one party's name, you know, we try to award it to that party or make that party responsible for it, because no matter what happens, that party's responsible at the end of the day, right? You can't force a creditor to change who they're going to hold liable, because when they made the decision to extend that credit, they based it on that person, right? Their income, their credit score, et cetera. And so now you can't tell them, well, I know this person doesn't have as much money and doesn't make as much money, but this is who you have to hold liable, right? So it should have been dealt with in the decree. If it wasn't, you should have hired somebody like Mr. Palin, because he would have gotten it done correctly for you. But that's all. Yeah, your debts are your debts. You're responsible for them. Get that out of your name. And funny thing is, you can't go back and do anything about it now. You can't go back to modify a decree to try to get a provision for the sale of the home. Now, generally, there's indemnification language in a decree that says that he basically says that whoever's responsible for the debt will make sure that the other party is not adversely affected for their failure to pay a debt. I don't know what's in the order, but it doesn't sound like it's a good one. So you get no equity in the home. Sorry to ruin your weekend.
So he has no rights at all, and so just kind of take his ball and go home. What would the legal advice be? Hey, look, just whatever happens, happens.
Yeah, do everything you can to assist her in the sale of this so you can get out of your name. Or use one of the three methods that James talked to us about earlier: ethos, logos,
ethos, pathos, and logos. Y'all know what I'm talking about. Y'all went to law school. It's all right.
Don't make assumptions about me. I was enrolled.
Okay. Had a tie for every day of the week. Let them tell you that story.
That's true. All right. So can we use the same lawyer? My spouse and I agreed to a divorce. We have a minor child. We have agreed on the details of the divorce. Can one lawyer represent us both? We get this question a lot too. Any thoughts on it?
It's not a good idea.
Sound advice.
I mean, what we can do is represent you and get your ex or your spouse on the line and let them know that we represent you and do our best to protect our client's interests in an agreement with both of you. We do that all the time as well.
Yeah, it's really impossible to represent both, because there's always going to be something that benefits one that doesn't benefit the other. And if you represent both, who do you pick, right? Like, there's a lot of things that pro se parties don't know to think about, that we're able to obtain for our clients or leave out for our clients that benefit them. Whereas if we represent the pro se party, we wouldn't allow that to happen. So no, you can't. You can't. And if your husband or wife tells you, hey, I find a lawyer who's going to represent both of us, come in, sign the paperwork, he's looking after both of our interests, that's bullshit. You need to find an attorney because nobody's looking after your interests, particularly when you're dealing with kids, right? Because there's so many like parental rights and duties and things like that, that if you don't know what you're doing, you could really end up cutting yourself short. And you certainly don't want to do that. It's one thing to screw up on property, but you certainly do not want to screw up on your rights for kids. That would cause some problems for you. You could end up, I don't know, owing $55,000 or something. So, anything else? Have we addressed everything that we were supposed to address today?
Yes, we did.
Cool. All right. So then I'm going to share my screen here. So we did say it at the beginning, and we did say it in the middle, thanks to Julie reminding us. And now I'm saying it here at the end, that what you've heard today, although very, very entertaining and a lot of fun to listen to, it's not legal advice. Don't take it as legal advice. Don't make any legal decisions based on what you've heard here today, except maybe we've, kind of given you something to think about or something to talk to your attorney about. But if you have legal issues like this, go out, hire an attorney that's experienced, that works in the area where your case is going to be filed. Yeah, but don't take anything we said here today as legal advice. And follow us on social media, right? I mean, Twitter, Facebook, not Snapchat, but Instagram. Is that all of them? LinkedIn and Facebook. Right. So follow us. And that's it. Anybody else got anything?
That covers it. Have a great weekend.
Yeah, you fellers have a good weekend.